Good evening, hello and welcome to the special broadcast. I'm Anusha Soni. It has indeed escalated and gone beyond taking pot shots and jibe at each other. I'm talking about the standoff between the government and the Supreme Court Collegium. An all-out battle between the Supreme Court and the Union government has taken a fresh turn. The Law Minister has shot a letter to the Supreme Court, to the Chief Justice of India, Justice D.Y. Chandrachud, seeking inclusion of a government representative at the state of initial selection. Now, usually there's a government version or the view of the government is sought after the initial selection process has already happened by the Supreme Court Collegium. Right now, once the name is finalized and vetted by the Collegium, there are only limited grounds on which the government can withhold a certain recommendation. Their power is limited. The Law Minister, through this letter, is seeking wider powers. The government wants the state or the government of the day to be a bigger stakeholder at the initial stage of selection of judges in this country. Well, this indeed is a drastic change from the present practice. If you take a bird's eye view from the pressure from the government is not merely the noise of the sound bites. The government for the first time has sought something very substantial. The Law Minister has also reminded the Supreme Court Collegium of the solemn promise made in the second part of the NJAC judgment that sought sweeping reforms. Is the NJAC being, brought back through a back door like the critics are arguing? Or this is the much needed push for reform coming from the government quarters? We talk on all these issues tonight.
Crept in legislature, a judgment of the court. उसी भावना में court cannot legislate.
Well, there's so much of talk about the NJAC judgment. There's so much of talk about what the NJAC judgment entailed and how it was struck down by the Supreme Court of India. Well, here's the not so talked about part. That part is part 2 of the NJAC judgment. After delivering that, crucial verdict from the Supreme Court of India, the 5-judge Constitution bench, there was a second part to the NJAC judgment that was put out. In this, there was wider process of consultation that was talked about, how a memorandum of procedure needs to be framed. All of those procedure would be spoken of. The memorandum of procedure would be prepared by Government of India. This was said in part 2 of the NJAC judgment. This is one judgment that the Law Minister is also asserting upon. The practice is in consonance with the direction of the second judge's case. The primacy rests with the Chief Justice of India. Nobody is taking away that primacy. But that said, there has to be more consultation that happens from the side of the government. The memorandum of procedure would be prepared in consultation with the President and the Chief Justice of India. If you read that order, the second part of the NJAC judgment, it records all of this. The CJI will take a decision based on unanimous view of the Collegium. MOP was supposed to be this one document that will settle this debate and confrontation between the government and the Supreme Court Collegium. We never saw it. That was never finalized. Eligibility, transparency, a secretariat that needs to be set up, complaint redressal mechanism, some degree of avenue for people to come forward and say, look, this particular judge is being appointed, there's a complaint that I want to raise. Some degree of interaction with public. In many parts of the world which are democratic, there is a process of some degree of interaction with the people as well. Well, that's the key question that we are asking. Is it time for more transparency in judicial appointments? Most experts, even the ones who support the present collegium process, would say that there is a need for reform. The judgments of the Supreme Court, in fact, talk about it. But how is it that we can ensure this reform really sees the light of the day? Well, joining us on the broadcast is Ashwini Dubey. He's an advocate of record in the Supreme Court of India. Ashpreet Karyal from the Congress Party is also joining us. C.B. Pandey, who's a legal advisor to former Governor of Uttar Pradesh and also a former judge, is joining us on the show. Tushar Gupta, who's a senior editor at the Swaraj magazine, is also with us on the show. Ashwini, coming to you first, Ashwini ji.
Yes.
The suggestion from the government that have a representative or from the government within the collegium. how drastic or path-breaking this is?
As of now, there are two things, Anusha. One, the Collegium is the law of the land which deals with the appointment of the judges. There are 5 senior-most judges of the Supreme Court who had been the chief justices of various high courts, who look into the credential of a person who is sought to be appointed on the as a judge of the High Court or the Supreme Court. They look into the academics, they look into the integrity, they look into the performance, and also the way he conduct himself in any High Court. That is the criteria which is being followed. As Anusha, we know that the judges are being appointed by the senior judges who have done well in their professional life throughout. They evaluate the need better than anybody else and can have a better insight of the candidate to be appointed by the post. Present collegium system gives independent judiciary, which is very much necessary for the India. See, the democracy does not mean only elections. Everything should not be appointed to the electoral process. The original constitution, which provides some safeguards, and gives autonomy to the Supreme Court and High Court, and that says that they are free to interpret the law. For example,
Ashwini ji, let's simplify this for our viewers. It's a given that collegium is the law of the land. It's a given that for now there is no other legislation or statute that governs the appointment of judges, and collegium system pervades. As it was held in the NJAC judgment that the constitution operates against any kind of void. So because NJAC is struck down, collegium system continues to operate. Let's talk about the not so glamorous part of striking down NJAC. The second part of judgment that was delivered, which spoke of setting up a secretariat, complaint redressal mechanism, a memorandum of procedure that needs to be finalized. Well, those promises haven't really seen the light of the day.
The NJAC was, I see NJAC is bad because of the two reasons. One, the NJAC Act said that there will be 2 members, either from the SC, ST, OBC and from minority, but there will be notable personalities. Notable personality, Anusha, you had been a lawyer before joining this media. Just tell me one thing, if somebody is head of the science and technology, somebody is head of the defense services, somebody is at the head of the agriculture institute, that the person, will he be able to assess and evaluate the characteristics, the academics, the legal acumen of a person who is sought to be appointed as a judge of the High Court or the Supreme Court? Point one. Second, Chief Justice of India was the chairperson in that NJAC, but with no board. Means the Chief Justice of India have kept. So there are 2 reasons. And at that point of time, when Supreme Court Advocate on Record filed a petition, the government asked, the Supreme Court Constitution Bench asked time and again, asked them to look into this aspect, and also the independence of judiciary and basic structure doctrine, which has been said in the...
And that takes me to the point, Ashwini ji, when the basic structure doctrine in some way, I'm not saying in a limited sense, was questioned by none other than Mr. Jagdeep Dhankar, who is the Vice President of India, also a noted lawyer, an eminent lawyer who knows the law very, very well. Tushar, I'm coming to you. How do you see the suggestions which are coming in from the Union Law Minister? The Union Law Minister is very well aware that collegium is the law of the land, and in the present system, there is no room per se, conventionally speaking, for a government representative to be accommodated at the initial stage. Your thoughts, Tushar?
Look, Anusha, I was hearing the previous speaker, and they say that collegium is the law of the land, but it wasn't something that was imagined in the constitution. Do I want my judiciary to be independent? Absolutely yes. Do I want the judiciary to be accountable? Absolutely yes. Every time the question of NJAC comes up, there is this whole separation of powers that we start hearing about, that the judiciary needs to be independent, there should be no involvement of the legislature, and rightfully so. But what have been looking at the judiciary lately, they have been interfering in the legislature. It's the judicial activism that worries me. Just on Friday, Anusha, they were dictating how TV anchors must behave. So tomorrow, probably a part of what I say or probably you say might anchor the lordships in the court, and we cannot do anything but, really look up to it. The second point about the acumen, which was spoken, that the committee member might not have the acumen. There have been plenty of cases, Anusha, and don't even get me started. I'll give you the example of the 3 farm laws, where the lack of economic acumen of the judges was what hindered the implementation of the laws. Now, I understand you need independent judiciary. They are best understanding or are interpreters of the law of the land. But you also need people who are experts in science and technology of economics. Because time and again, we've seen judges take decisions that are not in the best economic interest of the country. To give you an example of farm laws. So when someone says, oh, these nominated members, the 2 members within the NJAC would not have the acumen, I vehemently disagree, because even the courts on some issues do not understand the intricacies very well. Do they understand the law?
And sometimes,
Absolutely,
the propriety of procedure.
Under the sun? No, they do not.
Absolutely. Sometimes the propriety of procedure doesn't require to be a lawyer. You just need to be a voice which is recognized in the society. That point is taken. Harshpreet, coming to you. You're a lawyer yourself. You know the rule of law. You know the basic concepts of law, and you know how important it is for separation of powers. I don't want to go back to the history of Kesavananda Bharti or the dissent of Justice H.R. Khanna or the kind of role that was played by the then government in terms of how emergency was imposed and how there was a huge standoff between the judiciary and the executive at that point in time. But there's a history to why we have a basic structure doctrine. And that history is marred by the kind of confrontations that we saw. It exists because there was an attempt by then elected government to usurp the powers of people. That doctrine stands even good today. The law minister argues that when it comes to judicial appointments, things have changed, context have changed, and hence the government must have a greater say when it comes to judicial appointments. Judges cannot appoint judges anymore. Harshpreet.
First of all, what the Bharatiya Janata Party is trying to do is extremely, extremely dangerous for the democracy of India.
Yes.
It has expansive repercussions to it. It has dangerous repercussions to it. Very, very significant. And, the Bharatiya Janata Party is basically accustomed to violating the law of the land. They do not understand what separation of powers is. It's the job of the legislature to make the law. The executive implements the law, and the judiciary safeguards the law. And the government basically wants to have it all for themselves. Why can they not simply have faith in the judiciary? Why do they want to destroy the independence of judiciary? Let's understand this in very simple terms. If the government would have a say in the appointments of judges, in the transfers of judges, it would very well affect the decisions of judges. They are independent because the government does not have any say in them, in their transfers, in their appointments.
But I have a counterpoint. Ashpreet, I have a counterpoint. Collegium system, if I'm not wrong, is less than 3 decades old, is roughly 25 years. After the second judge's and the third judge's case, for most part of our independent history, it was the executive or the government of the day which was exercising greater powers when it came to judicial appointments. And apart from the disappointments that we have had some stellar judges on the bench of the Supreme Court, Justice H.R. Khanna, Justice Chandrachud, various other judges who have been in the history, Justice Krishna Iyer. All these judges did not come through the process of collegium, did they?
Well, definitely not. Nevertheless, here it's an entirely different question. Please see, I'll give you an example also. Media is another pillar of democracy, like the judiciary is. And we have all seen what the Bharatiya Janata Party has done to many media outlets and how, it all gets influenced because of the interference of the government. So therefore, we cannot have the same thing done to the judiciary. And number 4, the Bharatiya Janata Party is used to intimidation tactics. And this is yet another way of the Bharatiya Janata Party, by doing left or right, they basically want to have another avatar to NJAC and they want it to be tested again. That is why all of it is being done.
Well, history is checkered with precedents when the government has interfered in institutions, and of course the Congress party doesn't have a great record there as well. I'll come to you, Harshpreet. Tushar, there's a reaction I'll take to. I'll come to you. I'll take in a word from Mr. C.B. Pandey as well. He's very patiently listening to all of us. Before that, here's a reaction coming in from Congress leader and senior advocate Abhishek Manu Singhvi over the advice that has gone from the law minister to the Supreme Court Collegium to the Chief Justice of India. Listen in to this reaction coming
in. It is astonishing, strange and distressing that day in and day out, a new inroad, a new comment, a new issue like a shagufa is thrown in the air. Sometimes by the government, sometimes by constitutional functionaries. What is the purpose of this? It seems like becoming more and more sinister every day. It appears to be a concerted, organized system. First, you have not done any attempt to bring a legislation to amend the NJAC. Second, you have not attempted any initiative in a valid legal way. Suddenly out of the blue, when the law stands as it does, you suggest that members of the government should be part of the collegium. Suddenly out of the blue, you suggest that the basic structure, doctrine which has stood the test of time for decades, it's the pride of India and the envy of the world. It is the best bulwark against dictatorship. It is one of the most innovative, creative, evolving, dynamic doctrines of the Indian Constitution. Many other countries have copied it. Suddenly one fine morning you start attacking basic structure. What is the object of all this? You are unfortunately in a control freak mode. You are unfortunately trying to control institutions. You are unfortunately in a dictatorial mood. And now apparently the target is the judiciary. This is sad, it is distressing, it is ill thought out, it is not, it betrays a complete lack of constitutional ethos, of past precedents, and I have unequivocally, I would say, that this is to be condemned.
Well, that was Abhishek Manu Singhvi condemning the letter that was written by the Law Minister. Similar arguments that Arshpreet was also making some time ago. Before I go into Mr. C.B. Pandey, Tushar, a quick response from you. An interference by the government, an attempt to overtake the independence of judiciary.
I think it's a wrong narrative being floated. Look, one, the Collegium was not an integral part of the Constitution. It wasn't there when the Constitution was first introduced. And the composition of NJAC also has the Chief Justice, 2 senior-most Supreme Court judges, the Union Law Minister, and 2 nominated members. Let's not forget, it's not like the government is overshadowing the Supreme Court or the justices. It's just trying to be a part of it. And at the end of the day, the judges are going to give the orders. It's not the government sitting there. By saying that the government interference or the NJAC will kill the independence of the judiciary, what we are doing is raising a question on the integrity of the justices, just to defend the collegium system. That is what we're doing, and that's wrong.
All right, Mr. Pandey, coming to you and taking in a word from you. The entire fear which exists, not just, coming in from the opposition parties, but in some lawyers, and if you read the NJAC judgment and people who oppose the majority of the NJAC judgment, they argue that this is not about the basic structure doctrine. This is not just about the basic structure doctrine. This is also to do with the deep mistrust that exists between the government and the Supreme Court. And perhaps that's the reason that after the episode of emergency and the super sessions we saw, that history is a reminder to the corridors of judiciary that a powerful executive can take away their independence. Mr. Pandey.
There are 2 parts of your arguments.
Right, sir.
First is that letter which has been written by the Law Minister. I think this letter have no relevance because there is no such power vested with the Supreme Court that they can include any executive member of the executive or any eminent person in the collegium. There is no such law. This is the first part. Second part is also very important, and that is that there is a distrust about the procedure adopted by the Supreme Court Collegium. People, it's a very closed system. Now the Supreme Court or High Court Collegium, the functioning appears to be a very closed system. So this should not be a closed system, and that is why the judgment of the judge's appointment, they have suggested that there should be a memorandum of procedure. The only purpose of memorandum of procedure is that this should be there should be appointment. This initiation of the names of the judges should be very transparent, and there must be people should know how it is initiated. Today, nobody knows how the names of the lawyers, eminent lawyers are initiated. Anybody from one place to one place, you pick up the proper name and just put in the before the Chief Justice of High Court, and he sent those names to the Supreme Court, and Supreme Court sent to the government of it. And this is very close. This is the transparency required that every step of this entire process should be known to the public at large. This is a democratic country, democracy. You are going to appoint on a very high position, constitutional post, and people are unknown who are going to be appointed on that post. So that is the memorandum of procedure should be immediately appointed. And in the memorandum procedure, there will be some method so that even the government is interested to send some name to the Chief Justice.
Yeah, they should also have an avenue to suggest names as you're suggesting. Absolutely.
There should be, at least they can send their names. There must be some procedure.
Some procedure.
It's fine.
Ashwini ji,
finalized by the collegium.
coming to you
But
and,
there should be some procedure so that they
talking
can
about, there's a very important point that Mr. Pandey is making, that if the government has a suggestion about certain names that should be appointed, there has to be an official way to pitch in those names. Memorandum of procedure, the way and form that was thought after the NJC was struck down, hasn't seen the light of the day. But yes, those fears are not unfounded that a powerful executive can take on the independence of the judiciary. That point is taken. But that argument cannot be used to thwart every kind of reformative measure. The present collegium system, the manner in which it exists, is opaque and there's lack of accountability. Everybody would agree that we need more transparency when it comes to judicial appointments. How can we move in that direction? Ashwini ji.
Anusha, I have 4 points to make. So far as the accountability, transparency and the appointment system is concerned, there is not only 1, 2 or 3. There are two kind of, when the name of somebody is considered, 1, 2 senior most judges of the High Court, along with the Chief Justice, 4 judges of the High Court, including the Chief Justice of that High Court, they consider the name 1. And the second here, 4 senior most judges of the Supreme Court and the Chief Justice of India. Thereafter, the name of that person, selected person, is sent to the government. And governments, on the basis of the IB reports, the integrity, as I said earlier, and other parameters look into, and then finally select the name. This is point number 1. Now 2. So as we're talking about, because give me 30 seconds and then we will move further. The principle of independence of judiciary was derived from the theory of separation of powers enshrined in Article 50.
Yes.
Dr. B.R. Ambedkar, the chairman of the drafting committee, said in the Constituent Assembly, there can be no difference of opinion in the House that our judiciary must both be independent of the executive and must also be competent in itself.
Yes.
Number 2, independence of judiciary is very important for any democratic country and citizens. Losing the same would get common man further entrapped to the political games, which would be no good. Now, point number 3. Prior to 1973, Anusha, another point, then you may move on. Until 1973, there existed a consensus between the government of the day and the Chief Justice of India. And what we saw in 1973, Justice A.N. Ray was appointed as the Chief Justice of India. This violated the convention formed earlier, since Justice A.N. Ray superseded 3 other Supreme Court judges senior to him. Again in 1977. Another Chief Justice was appointed who superseded his seniors. So it was already there, and then only the first judges came in 1982. What is as of now? The law of the land is that Collegium only appoints. So writing these kinds of letters, will it hold water? Is this
Okay. No, you have pointed out to the history of and the context in which the Supreme Court, the second judges and the third judges case came in. I'm acknowledging that history. I'm acknowledging the seriousness of the history. But how do we move forward in this country in 2023? And how is it that the present day collegium system can be reformed much further? Tushar, coming to you. When the vice president, the sitting vice president, and more importantly, somebody who's been a lawyer himself, calls into question the basic structure doctrine, the historic case of Kesavananda Bharti, which stood during the times of emergency, which upheld the constitution, which made sure that no powerful government can take over the constitutional values of this country. When the vice president calls the basic structure doctrine a judicial creation, is it not some kind of attack on the independence of the judiciary?
Maybe not, but again, it's a very subjective matter, Anusha. But at the end of the day, what people are now beginning to witness is too much of judicial activism. Look, at the end of the day, you cannot deny it, but the last hope of 1.4 billion people in this country is the apex court. Our fundamental rights are violated. We approach the Supreme Court. But what people are lately noticing is a lot of judicial activism. I personally was appalled by the observations 2 justices made against TV anchors, making them responsible for all the hatred and divisions within the society. I was appalled when they called someone having a loose tongue and blamed her for the violence on the streets. So at the end of the day, while I want my judiciary to be the hope that it has been for the Indian citizens, to be the strongest pillar of our democracy, I also want it to be accountable. And the closed door system currently we have, it raises a lot more questions than it answers. And some reforms going forward are absolutely necessary. Now, the government is not saying that the justices won't be a part of the selection process. They're not trying to overrule it by the numbers, but they're just trying to have a say in it. At the end of the day, the orders are going to come from the judges. But what we are missing is accountability, and what we are getting is a lot of activism, and that, frankly, worries me.
Ashpreet, if Congress was in power, I would have asked you the same question. But I think as a party which has governed the country, administered the country for a good part of history post-independence, I think it's incumbent that there should be judicial reform. There should be reform in the present collegium system. While you may blame the present government for trying to take over the independence of the judiciary, while the tables could turn, which government would have the might then to call for judicial reforms? There's a old legal maxim, you'd know about that no person can be the judge of their own cause. And I think that applies to Indian judiciary and Supreme Court as well.
Well, it also applies to the Bharatiya Janata Party. Let's understand what the principle of natural justice says. It says that there cannot be a conflict of interest. Now, there are many times, many occasions when the Supreme Court has to look into the policy made by the government, a deed of the government. And if that very government, that very party would have a say in their appointments, in their transfers, how would it not be a violation? How would it not be against the principle of natural justice? How would it not be a conflict of interest? Number two, as far as the reform argument goes, the collegium might or might not need a reform, but the government is definitely looking for subservience from the judiciary. They want it to be subservient to them, and that's why they're basically trying to interfere. Number two, on December 8th, the Honorable Court had categorically told the centre that collegium is the law of the land. It should be adhered to. I don't understand what problem does the Bharatiya Janata Party have in simply adhering to it. And number three, can you imagine a democratic India without the basic structure doctrine, without the case of
I don't think the basic structure doctrine should have been called into question in terms of judicial appointment. But that being said, the government does have a case when it comes to judicial reform in this country. The NJAC Part 2 judgment, where the Supreme Court acknowledges the need for a greater detailed memorandum of procedure, for having some degree of a mechanism for complaint redressal and much more. All those reforms are pending and should happen, and we hope to have these debates and discussions in the times to come. I thank you all, Ashwini Dubey, Ashpreet Kardial, C.B. Pandey and Tushar Gupta. Thank you, gentlemen, for joining us on the broadcast. My colleague Ananya Bhatnagar has been tracking the story from the Supreme Court of India. He also got us those exclusive reactions coming in from Dr. Abhishek Manu Singhvi. I'm cutting across to him. Ananya, this is not the first time that a debate of this nature is happening. In fact, this has dominated the discourse in the last few months. But a suggestion that you should have a government representative at the initial stage when the collegium makes a recommendation is clearly suggesting a departure from the present convention that exists. How is that being received in the corridors of the Supreme Court? What did you pick up?
Well, Anusha, this debate had begun on, if you remember, in the month of November to December last year, when the law minister actually came out and spoke at an event in Gujarat where he said that the collegium system is opaque. And since then, this has been continuing with to and fro between the Supreme Court and the central government. And coming back to your question, the legal corridor has a different opinion on this. There are different opinions that are going across. While the majority of them say that inclusion of the government into this particular system would actually hinder the basic structure of the democracy. But at the same point of time, there are suggestions that if at all there, if not government, but then there should be some independent members that should be there on the search committee, so that the collegium does not appoint the people only whom they know, but also somebody who is very deserving, and there should be a proper search committee.
As you point out those different nuances of the debate, I'm also reminded of that historic press conference of the 4 Supreme Court judges. And other than various other issues that they had raised in that press conference, if you read through that letter that was put out by the 4 dissenting judges, as they were famously called, they also talk about the memorandum of procedure and judicial appointments. So the entire cry for reform and the need for reform is not just something which is being heard from the executive or the government of the day. There is a section even within judiciary, even amongst the sitting judges, who believe that the reform, the process of reform for Supreme Court Collegium, for the higher judicial appointments in the country, is a task unfinished, and it should be done as soon as possible. Well, as earlier said, under the 2nd judges and the 3rd judges case, collegium system is here to stay. It's the law of the land. But that doesn't mean it doesn't need reform. It does need reform, and we'd keep talking about that. Well, with that, it's a wrap from my side. My colleague Shivani Gupta joins you with Plain Speak. Thank you for watching.